the three accused persons have been arraigned before the district court. And counsel for A1 and A3 applied for the matter to be heard by a properly seized district court, which has proper jurisdiction, based on the territorial jurisdiction from which the accused persons were arrested. And this flows from Section 51(5) of the Court Act, as well as the Extradition Act, Act 22. So that was the gravamen of discourse today with the court, and then with the state attorney. But the court, we raised a preliminary legal objection regarding hearing the jurisdictional issue. That's the formal application that has been placed on before the court. The legal objection was about the proper court to hear the application proper, and then the court said she seized with the jurisdiction, so she vacated that preliminary legal objection. We are coming back on the 13th of January to determine the formal application before the court, before we even go into the merit of the extradition proceedings, wherein if the requesting state has brought in the documentations which will inform the court, the proper court, if after the application is properly heard and we know if it's basic court or Medina or anywhere from relating to where they were arrested, then we know which court will properly hear the extradition proceedings, and based on what evidence the court will determine either the persons or the accused persons or the fugitives, as they claim, will be transmitted or released to the not convoluted by political witch hunting and all that, as the law requires, should be gone into before any person would grant it, either through diplomatic channels or judicial process. So basically, that's what happened.
There was the issue of a fourth accused person who had mask on, and there was the occasion for you to request for his identity to be known. How did that go?
That one, we had to determine it in chambers. It borders on security. Yes, so I wouldn't want to go into it.
Okay. As far as the grant of bail is concerned, my lady indicated that she wasn't convinced that they will appear before the court. Looking at the nature of the case, the wide scope of it, she definitely dismissed the bill. How did it come to you? How did you feel about that?
Yes, as you heard, the counsel do the application from A1 to A3, and then the prosecution's state attorney also making a submission. Bill is at the discretion of the court, but when you read the fine black letter law of Act 22, bill for A1 whose name is returned on the indictment has not really crystallized. That's why we didn't apply for bail for A1. But A2 and A3, their names are not on the indictment that was returned by the USA or the state, the Department of Justice of the United States. So that's why we prayed for bail. But still, per Article 19, 14, and then Section 96 is still with the bosom of the court, the judge, and she exercises her discretion in favor of the state rather than the accused persons or the alleged fugitives, which we know A2 and A3's names are not on the indictment from the USA, and then it's just for the state to hold them that they are just collateral damage from the arrest of A1, and then they've also been arraigned. So that was the argument we were putting for as a team, yes.
So now that this has happened, what happens to A1, Frederick Kumi, being the lead suspect in all of this?
That one remains strategy. We can't put it out here. So we'll end it at that. Thank you so much.
All right, counsel. Thank you.